I'd like to introduce our main speaker for today. So Dalia, you're on deck. Dalia Stokes is with us today. She's a native Houstonian and practices probate and estate planning law here in Houston, and has graduated from the South Texas College of Law in 1981. And for the last 33 years, she's practiced law with her partner, Bobby Bayless, under the law firm's name, Bayless and Stokes. Dalia is board certified in estate planning and probate and has volunteered extensively with the Houston Bar Association as well as for numerous community organizations. In the 90s, Dalia ran for judicial positions as a Democrat. Falling just short of winning elections to the probate bench in '98, Dalia, along with a handful of other Democratic women, started the River Oaks Area Democratic Women, also known as the Road Women, a group that she ran for 8 years, and it's still going strong today. In 2005, Dalia and Bobby turned the downstairs portion of their law firm into a year-round Christmas shop called Christmas Rocks. And it's still going strong, and it's the only year-round Christmas shop in Houston. And just this year in June, Dalia and Bobby were grateful to celebrate their 40th anniversary by getting married. Thanks to Jim Oberfell and the efforts of hundreds of thousands of people around the country who labored for gay equality for decades. Gary Taylor and I got to play that wedding ceremony, and that's my wonderful souvenir cup that we have of that. Dalia is also the attorney that I used when my mother passed away. She helped me navigate my mother's very complicated estate that she had, and I'll be forever grateful for the kind of help that I got when I was in the pressure cooker and didn't have a clue what to do next. Hopefully you'll get a better clue than I had then. Please welcome to the stage my friend Dalia Stokes.
Thanks so much. I am very honored to be invited to speak with you all today, and thrilled to learn about Oasis. So thank you, TC. We're here today to talk about God. Good old death. Anyway, so that's what I do. I'm talking Probate 101. If you wouldn't mind, I'd like to see how many folks have never been involved in the probate process at all. Just a little show of hands so I get an idea. Okay, so some have, some haven't. This is about half and half, and that's not unusual. But in addition to probate, I do estate planning. I help people get their documents in order, their wills or their trusts or whatever, and then I can help people with the probate process, as TC mentioned. So it's becoming less onerous, I think. I can say that in Texas, but it is always a really good thing to get prepared for it. What some people want to know just right off the bat, what is probate? What's the purpose of it? And I would just say in general, it helps, it's a process by which, a legal process, someone can pay the debts of the decedent if the decedent has assets, then gather the assets of the decedent, marshal the assets, and protect them. It clears title to the property of decedent, and then ultimately transfers the decedent's estate to the beneficiaries. So that's basically what it is. And it can be a very complex thing, or it can be extremely simple. It depends on so many things. There are two main types of probate. One is where the decedent died with a will, and that's when we call that the person died testate. And then there's where they died without a will, or intestate. So there's much is made about it's better to die with a will. You know, it's better to have a will because it tends to be less expensive and less cumbersome, and achieves the objectives of the decedent better. So that's basically what I do, you know, is try to help people get in that position where they have the will and they, you know, then die with a will. So things are less expensive. So I'm going to talk about that just a little bit, just to give you the broad brush. And TC said I'd helped her navigate the probate of her mother's estate, and I think she's still actually navigating it. I mean, it just sometimes things come up on down the road. You learn about an asset here or there that you need to take care of. And so it can be a real quick process, or it can go on for years. And in her case, it's been going on for years. Luckily, she can do most of it now all by herself. So generally speaking, if you have a will of somebody who has died and has named you as their executor or executrix, and I just use executor because it's just easier right now, then you would need to have an application prepared and file the original will and that application for probate with the county clerk in Harris County, county clerk. I'm talking about Texas probates here. It's not going to be the same in every state, I promise. Might be similar, but it's not going to be the same. So then you have to wait approximately 2 weeks before you can have a hearing on that application. But then you go down with your attorney to have the hearing, and it usually is pretty short and sweet if the will was self-proved. And the judge will admit the will to probate and appoint the person named in the will as executor. And then that person gets their letters testamentary, which are kind of the keys to the kingdom, and then that's what allows that person to be able to transfer the title to property, to gather the assets and take care of estate business. After they're appointed, there's a number of statutory requirements. In other words, the probate code says that executor needs to do X, Y, and Z. One of the simple things is publish a notice to unsecured creditors in a daily paper of that county. And that's easily done. It's just, if you don't do it, you can be removed, and you have to file proof with the court that you did it. So it's just some routine things like that. But most of the stuff that the executor ends up being involved with is taking care of the assets, finding the assets, and dealing with beneficiaries. Somewhere along the line, early on in the first 90 days, an inventory needs to be prepared. And now, as of just a few years ago, there's an option to do an affidavit in lieu of an inventory. And that's where the executor prepares an inventory and gives it to the beneficiaries, and then signs an affidavit filed with the court that says, yes, I've complied with this requirement. And the reason some people want to do it that way is because then the assets of the estate are not public record, so that provides a little bit more privacy. The downside, and sometimes you can't do it. Sometimes the will was done before this law, after this law came into effect that allows the affidavit, and the will says that, uses old language that says they have to file an inventory, and sometimes the court will make you do that. But frankly, although I can see the advantage of the affidavit in lieu of inventory, I'll tell you what the disadvantage is, and that is the inventory becomes the basis of the value of all your property that came from the decedent as of the decedent's death. And so you think you're going to know where it is, but I can't tell you how many people don't know where the inventory is after, 10 years down the road when they sell that property. So they call me. Now, I don't know where it is. But if it was filed of record, you do know where it is and you can get it. So that, I'm promising you, can end up biting you. But most people go the way of the affidavit if they can. And then, of course, as I mentioned, paying the decedent's debts, one of which is pretty routine, is the decedent's final personal tax return. That everybody needs to file. And so that has to be done, and some people forget about it, and then they go, oh my goodness, where's that money coming from? And then distributing this decedent's assets. So that's basically what the probate process is. And when there's a will, in Texas we have what they call independent administration, And so the good news there is the executor can act independently of the court. In Texas, we do have an independent administration, so the executor then, if they're named as independent executor, which most wills do in Texas, they can act independently of the court, meaning they don't have to get permission from the court to do their job. So just as one example, let's say the decedent had a house, then if you're not independent, you have to file an application with the court to sell the house. You have to show some basis for how you arrive at the selling price. You have to ask the court for permission to accept an earnest money contract. You have to ask the court for approval of the actual sale. It's very cumbersome and expensive process. But if the person is independent, then they can do that all on their own. So that's just one example. So the other way of probating a will in Texas is called a dependent administration. Probating an estate when there is no will is a dependent administration. So a person dies without a will, and yet they have assets, and those assets need to be transferred, and debts need to be paid, just like if they had a will. So then someone seeks to get appointed the administrator of that estate, and then if they do get appointed, they're in charge like an executor's in charge, only they have to get court permission for everything, and it's usually quite expensive and cumbersome and not a lot of fun. There is one way around that, and that is to get consent of all the beneficiaries. If you can show, usually you have to have an heirship hearing to show who the heirs are of that estate, and if you can show who they are and get them to agree to ask one of them or one person to act as the independent administrator, then you can ask the court to authorize that, and that'll save a lot of time and money. So those are the two basic approaches to probate. The good news is there's some alternatives that have come up over the years, and many of you all probably are aware of the like payable on death accounts, POD accounts, that transfer automatically on death. So just a simple, let's say, checking account could be set up so when you set it up that you check the box that says POD, and it names the person who would get that account. And that is all you have to show is a death certificate. There's no probate process. Completely goes outside of the probate process. So that's a simple technique. Another is there are a few assets, as you well know, that pass by beneficiary designation. So let's say like life insurance and 401ks and things like that, where you do a beneficiary designation, and IRAs, and they're going to go payable on death, showing a death certificate to the person or persons that are named. So that too will pass outside of probate. In other words, it doesn't require the probate court to help you retitle the asset. And then the thing that has gotten a lot of attention in the last, I'd say, 20 years are trusts. And I'm sure you're familiar with trusts, and there was a whole lot of hype, I'd call it, about how trusts were so great because they would save you from estate taxes. And most of the time, the people that were saying that were wrong. In other words, it's misleading hype for trusts. It didn't save estate taxes. There are some trust techniques that can be put into wills or living trusts that will save ultimately some estate taxes. But right now, our estate taxes, everybody has an exemption of over $5 million, like $5.4 million, every single person. So the majority of people in the country, of course, don't have that much, and so there's a lot less worry about, oh my goodness, I don't want my estate eaten up by estate taxes. So people don't have to jump through as many hoops as they were a while back. And I think that's probably a good thing. Everybody thinks that except eleemosynary institutions. That'd be you, Oasis. Churches, colleges, Oasis, anybody that is getting left the money because they'd rather it go to you instead of the government. Now, if it's not going to the government, they have no motivation there, or they lose a lot of their motivation to make their charitable donations. So that's who really, really, really should care. And they do, believe me, they do. So that's, trusts are a good thing. I do trust for some people, and sometimes I do trust inside wills. That's a good technique. If you have parents who have wills and they haven't died, and they haven't left things to you in trust, you might talk with them about doing that. The beauty of that is it passes to you, it passes to a trust for you. You're the trustee, and it is protected from any creditors you might have. If they leave it to you directly, you cannot then put it into a trust and protect it from creditors. Okay, so it's, you may not have creditors, you may never have creditors, but you don't know. And so it's not a bad deal. It also helps keep it identified as your separate property. So if you get into a subsequent relationship / marital relationship, that it is not subject to division upon separation, divorce type situations. So those have advantages. The only downside really is it's a little bit more cumbersome, because it's going to have to have its own taxpayer ID number, and it'll have to pay taxes every year as a separate tax-paying entity. But it's a good thing. So the one thing I thought was newer than anything else that came about the last legislative session is something called a transfer on death deed. How many people have heard of that? Anybody here heard of that? You've heard of it, good. Well, anyway, so for so long, people would be motivated to do a will only because they had a house. And we have had what they call a small estate affidavit process. So if your estate was under like $50,000, you could transfer it by the small estate affidavit. It wasn't as good as a will in terms of, the titling. There could be some issues, but it was good. But anyway, so now the legislature has come up with something called a transfer on death deed. And where I think they envisioned a lot of this happening was a couple leaving it to each other in this form, and then it would pass outside of probate. It would just pass by this form. So again, a death certificate showed that title had passed into the survivor. So that would then obviate the need for a will in a lot of cases, probably, because the other assets they could title in payable on death forms, or whatever I just said, life insurance and all those IRAs and whatnot that passed by beneficiary designation. So it's so new. The transfer on death deed form and process is so new. I am a little bit hesitant to say I think it's the greatest, because I don't really know. But the way for it to be effective, you not only have to execute it, but you also have to file it of record in the county. And then, and that's fine. I mean, that's not a big deal. But in addition to that, there's a way to revoke it. But I'm not quite sure how easy that is to do. I haven't talked to a single person who's done that yet. And you can, go your separate ways and decide, we're not going to do, we don't want to do it that way. I don't want to leave my half. So I can't say with 100% accuracy that I know this is slick as glass, but I think it has some merit, and I've brought the form so people can have it. I think you could Google and find it, but I didn't know how easy it might be for people to find it. So a little bit later we can pass these out, or people can get them as they want them. I think I think I've covered most of the waterfront here, and the one thing I'd say is the other option, has already been thought of by Smythe and Taylor, and that's take it with you when you go. And it goes like this: I'm taking it with me when I go. Look behind my hearse, you'll see a trailer rolling slow. I spent my lifetime collecting all that stuff, so I'm taking it with me when I go. So, I don't know, am I supposed to ask if anybody has any questions?
I just got covered. I can't believe it. I knew that when Dalia would come here to talk about these things, there would probably be extensive Q&A, and everybody has questions about this stuff. So what I'm going to do is give the microphone to Eric and let him run around for as many questions as we can get in, because it was hard to listen to the facts because I was so busy formulating questions. And maybe the rest of you feel the same way. So here you go, Eric.
Thank you. Let's give a hand for Dalia real quick. Thank you so much. All right, hands up for questions. Johnny.
Yeah, thank you for the talk. The estate tax exemption is portable, right, between husband and wife? So would it be $10 million before we have to worry about getting a trust?
Well, that's a very complex question. Yeah. You use the word portable. Portability, that's a legal concept that almost nobody uses. I mean, it's good, but I keep telling my colleagues that, you know, when I counsel people, I keep trying to figure out ways to bring it up in the conversation because nobody has that much money that I've helped. Yeah. But what we're talking about there is a husband and wife can plan an estate where they already have built in the like bypass trust that will prevent the taxation, the stacking of the estate, so that they would not be taxed on the second to die would not be taxed on a stacked estate. So that's one way.
Okay.
And then the other way is they have this law now that says you can a spouse can elect at the death of the first spouse to take or import the exemption of the first spouse to die. And the problem I've been told with that is that that then they have to file a 706 for the first spouse to die, even though they didn't need to otherwise.
Okay.
So I don't know if it's that big a deal to do that, but that is what I understand.
I want to also ask real quick. I sometimes struggle sitting down with people and trying to explain them the importance of having a will and getting it done, not just for property, but I have one done because I didn't want my parents to give me a religious burial. Like, I wanted it to be separate. I've given a copy to like a lot of people, and like in case they try to do something, please stop them. What things do you say to people to get them to encourage them to actually get their wills, power of attorneys, medical directives, all that stuff taken care of?
Well, it never comes up because they already, when they come to me, they're wanting that. And so, frankly, honestly,
what could we say?
I have no idea. No, zero. No. Seriously, it's an understatement to say that it is more expensive if a person dies without a will. It is just simply, and it causes problems for the people they leave behind. And I think the vast majority of people do care. They don't want to cause problems. In fact, they want to make it easier. That's what they're thinking of. So most of the time, that argument appeals. You're going to save money and you're going to help the people you've left behind because they're already in a state of what I call emotional, psychological turmoil. They've lost somebody that's very important to them. And so it's not a great time to be, flying by the seat of your pants, so to speak. So that's the best argument I can think of. But that said, some of the smartest and most, well-meaning people don't get this done. It really happens, and so I can't quite explain that, but You know, all of that just makes extra work for lawyers. That's the other thing you could say, you know. I mean, it's true. And they love it when you do your own will. They love that. Because usually it causes problems and you get into some litigation. And then they really love that because that's a lot of money for the lawyers. And there's just no way around it. Part of it won't go away. But all the stuff I've been telling you about were ways to avoid spending money on lawyers, okay? Yeah.
So I have I have a reason, one reason beyond financial and legal, why it's important to have a will. And a lot of people don't really realize that I'm someone who was actually denied an inheritance by my mother, not because she was trying to prove a point, but just through some bad estate planning. And what people don't realize is that passing on an estate is not just about finances. It's an acknowledgement of kinship. It says to the people that you love, I care enough about you to leave what I have. And at a time when, you know, back in the caveman days, what you were leaving was a spear. It was going to help your family to survive. You might leave a spear to your son and something to help, you know, grind flour for your wife. And so that was going to allow your family to have an edge to be able to survive. So now it's not so much about, you know, what you leave to your beneficiaries can be small, but it says to them, I value you. You're part of me. You're a part of my family. And so what happens when people don't receive that, or when there's a discrepancy, when there's a disparity between siblings who receive it, it feels like a rejection. It's very personal. It's like, I didn't value you enough to leave you this. So if you have people that you care about, try to be upfront, I think, ahead of time, and let them know what your planning is. If you have a reason for giving one person more than another, let them know what that is ahead of time so that they don't find out about it after the death and all was like, well, wait, they didn't care about me as much as they care about the other person. That causes so many problems in families. I cannot tell you. Luckily, when I was denied my inheritance, my stepsisters got it instead, and they were very honorable people and split the inheritance with my sisters.
Wow.
Even though they were not bound legally to do so at all. So, but I very remember, and I well said, it's not like I needed the money, but to know that my stepdad didn't value me as a part of the family when he left all the inheritance to my stepsisters was kind of hurtful. So even if you don't do it for legal reasons, you know, you can find a way just to kind of remember that this says something. Doing or not doing it says something to your beneficiaries.
I think that's a very good point, and the more equitable a person can be in their will, the better, because it's less likely to cause problems. And I will mention, and I'll date myself when I mention this, but does anybody remember, this goes back about 45, 50 years, the movie Zorba the Greek?
Oh, yeah. Oh, yeah.
Yeah.
Oh,
Well,
coming in
that's an example of where you didn't have a probate process, where the person dies and just all the women in the town in their dark clothes come in and just, you know, clean the place out. It's just, everything's just gone. And it's like it's an accepted method, you know. It was a very, you know, sober scene, odd, but that, you know, you don't have much more than that if you don't have any kind of probate process.
We've got time for one more quick question. Anybody with a quick question? It's your bird's birthday, so.
If you've been through bankruptcy, which I have, will the creditors that you were released from during bankruptcy be able to come back against your estate and wreak havoc on it?
I think, I'm not a bankruptcy lawyer, I think the answer is once your debts are discharged in bankruptcy, that's it. But the other side of that is if you haven't been through bankruptcy, you know, just dying doesn't get rid of them. They can come, yeah.
All right, I'm afraid that's all the time we have. I have one request question that came in from an anonymous source. This person asks, If my will is already written, how can I add Oasis as a beneficiary? Not my question.
Well, you know, we used to say do a codicil to your will. We used to say that. But now I don't say that. With only in certain circumstances, like if the person is, you know, losing capacity, then I would say do a codicil. But by and large, with the since we have the documents all on our computers and in our word processing, it's just much better to go ahead and do a new will and include Oasis. And part of the reason is because it's on word processor, and the other part of the reason is then you're not keeping up with two documents, because when you do a codicil you have to keep up with the original will and the codicil, and believe me, oftentimes that does not happen. So it's better to have that most recent will.
Excellent. Thank you. Let's all thank Dalia one more time.